Alright, welcome back everybody. News Now Wyoming, and once again we're going to be covering the Michael Sexton, which is the Pike's Peak Authority, thank you, versus Colorado Springs. This is the order from the judge when he dismissed the case against the stupid cop in his official capacity and the city of Colorado Springs. He's also going to summarize the case better than I did in my short 20-minute video or 18-minute video. So I figured we would actually take time to read this. Probably not the whole 44 pages, because judgments are not always very entertaining. But let's go ahead. This matter is before the court. See, that's boring. City defendants and plaintiff filed a response and the city filed reply. On June 7th, 2019, plaintiff left the 7-Eleven store near the intersection of 30th Street, Colorado Avenue in Colorado Springs. Officer Anderson drove by that location in his patrol vehicle while plaintiff stood in the parking lot. Hold on, there is a note. Oh, background. Facts below are taken from plaintiff's complaint, docket number 1, and are presumed to be true for purposes of ruling on defendant's motion to dismiss. Again, as we've discussed many times, he's got to take it in the facts most favorable to the plaintiff. As Officer Anderson passed, plaintiff flipped off the car with his middle finger. Officer Anderson saw plaintiff's gesture, made a U-turn across 4 lanes of traffic, and asked plaintiff if he needed help. Plaintiff told Officer Anderson that he did not need help. Actually, he said kick rocks, but okay. And Officer Anderson began to drive away on 30th Street. He said, kick rocks, like anybody should tell a cop. As Officer Anderson drove away, plaintiff looked both ways and seeing no cars in the area crossed 30th Street. Officer Anderson made another U-turn and drove towards plaintiff. Plaintiff began recording the incident on his phone. Plaintiff, standing on the sidewalk, flipped Officer Anderson off again. Immediately after plaintiff flipped him off for the second time, Officer Anderson activated the police lights on his car and pulled over. Officer Anderson jumped out of his police car, grabbed plaintiff, pulled plaintiff to the police car by plaintiff's wrist, and shoved plaintiff against and over the hood of a police car. Plaintiff asked Officer Anderson to please calm down, but Officer Anderson continued to pin plaintiff to the hood of the police car with his entire body weight while wrenching plaintiff's arm behind plaintiff's back. Plaintiff told Officer Anderson that he was not resisting and indicated with his body language that he was not resisting. Plaintiff asked Officer Anderson not to rough him up and told Officer Anderson he was hurting his arm, but the stupid officer continued to pin the plaintiff to the hood of the police car. Plaintiff never said anything or made any gestures to indicate that he had a weapon, was attempting to flee, or was resisting. Stupid cop then placed the plaintiff in handcuffs, and the plaintiff asked Officer Anderson for his name and badge number, but Officer Anderson... Oops. Wrong button. For his name and badge number, but Officer Anderson refused to provide them. While plaintiff was in handcuffs, Officer Anderson directed another Colorado Springs Police Department officer to search plaintiff's pockets. He then asked plaintiff why he was making obscene gestures, and plaintiff responded that was his First Amendment right. He then began gave shifting reasons for detaining plaintiff before telling plaintiff that he had detained plaintiff for jaywalking. Plaintiff was released from the handcuffs and issued a citation for jaywalking. Plaintiff had been in handcuffs for approximately a half hour by that point. While plaintiff was in handcuffs, plaintiff noticed another individual crossing 30th Street at the same location the plaintiff had. When plaintiff pointed this out to Officer Anderson responded, "Well, sir, since you pay our bills and stuff, we want to give you our full attention." At this point, there were multiple officers on the scene. None of them contacted the person crossing the street. After plaintiff was released, he attempted to speak with Officer Anderson's superior, who was on the scene. As plaintiff complained to the sergeant, Officer Anderson came over and began arguing with plaintiff and revealed his true motivation for arresting Mr. Sexton, the fact that Mr. Sexton had flipped off defendant Anderson. Officer Anderson issued a plaintiff a citation under Municipal Court Code 104, which states every pedestrian crossing a roadway at any point other than within a marked crosswalk or within an unmarked crosswalk at an intersection shall yield the right of way to all vehicles upon the roadway. But C is where between adjacent intersections at which traffic control signals are in operation, pedestrians shall not cross at any place except in a marked crosswalk. So that is very important, right? Between adjacent intersections at which traffic control signals are in operation. Neither one of the one street was, but the one next to it was not, so they are not adjacent. The citation states that subject crosses streets in between two marked intersections. Colorado Springs prosecuted plaintiff for almost 3 months before dismissing the charges against him. At the same time the charges against plaintiff were dismissed, Colorado Springs found that Officer Anderson had violated his discretionary judgment policy, resulting in disciplining Officer Anderson. However, Officer Anderson was not disciplined for his wrongful arrest, clear violation of the First Amendment, and unlawful use of force. Plaintiff alleges that Officer Anderson's treatment of plaintiff was pursuant to Colorado Springs' customs and practices of unlawful conduct. Plaintiff brings the following claims against both defendants. 1983, Claim 1, First Amendment violation of free speech. Claim 2, First Amendment retaliation. Claim 3, Fourth Amendment unreasonable seizure. Claim 5, Fourth Amendment excessive force. And Claim 6, Fourth Amendment malicious prosecution. Plaintiff brings Claim 4, Fourth Amendment unreasonable search against Officer Anderson only. Defendants move to dismiss the claim against Officer Anderson due to failure to state a claim and qualified immunity. Defendants move to dismiss the claims against the city due to plaintiff's failure to identify a CSPD custom or policy of abridging First or Fourth Amendment rights. Okay, so here they're going to talk about the legal standard. Again, is this enough on its face that it would survive? Officer Anderson brings claims against Officer Anderson in his individual and official capacities. Defendants argue that plaintiff cannot bring claims against Officer Anderson in his official capacity because plaintiff also names the city as a defendant. Interesting argument. Plaintiff agrees that it is proper to dismiss the claims against Officer Anderson in his official capacity as duplicative, but only if the city is dismissed. Accordingly, the court will dismiss the claims against Officer Anderson in his official capacity. Where the entity is also named, there is no need for an official capacity claim. And that's the Colorado case. So, District of Colorado. I'll have to see if that's got any weight anywhere else. I've never actually heard of that. Officer Anderson argues that he is entitled to qualified immunity on all of plaintiff's claims against him in his individual capacity. Docket number 22, qualified immunity, balances two important interests: the need to uphold public officials accountable when they exercise powers, irresponsibility, and the need to shield officials from harassment, distraction, and liability when they perform their duties reasonably. So a court should resolve questions of qualified immunity at the earliest possible stage of litigation. However, a plaintiff facing qualified immunity challenge still does not have a heightened pleading standard. And that's 10th Circuit. Under the doctrine of qualified immunity, and it is just doctrine, it's court-created doctrine, right? Government officials, and what pisses me off the most about it is 42 U.S.C. 1983 was created by Congress to hold bad government responsible, so we can sue them. And then out of nowhere, out of nothingness, the Supreme Court just creates qualified immunity to protect them against the laws that were just passed by Congress. I mean, nothing about qualified immunity makes any sense at all by any legal standard. No attorney has been able to tell me where qualified immunity actually was brought into law by any law. It was only Supreme Court. Okay, anyway, sorry you guys. Under the Thus, to survive a motion dismissed under Rule 12b-6, where qualified immunity defense is implicated, the plaintiff must allege facts sufficient to show, assuming they are true, that the defendants plausibly violated their constitutional rights. When a defendant raises the defense of qualified immunity, a plaintiff carries a two-part burden to show. The defendant's actions violated a federal constitutional or statutory right, and if so, that the right was clearly established at the time of the defendant's unlawful conduct. Courts are permitted to exercise their sound discretion in deciding which of the two prongs of the qualified immunity analysis should be addressed first in light of the circumstances in the particular case. Plaintiff alleges that Officer Anderson stopped him without reasonable suspicion, probable cause, or a warrant, causing an unreasonable seizure. Defendants respond that Officer Anderson is entitled to qualified immunity because he had both reasonable suspicion and probable cause to contact and detain plaintiff. The Fourth Amendment provides that the right of the people to be secure in their persons, blah, blah, blah. A seizure of one's person occurs when a government actor terminates one's freedom of movement through intentional means. Supreme Court has identified three types of police encounters with citizens: consensual encounters, investigative stops, and arrests. Consensual encounters are not seizures under the Fourth Amendment. Investigative detentions, also called Terry stops, are seizures within the meaning of the Fourth Amendment and allow a police officer to briefly detain a person for investigative purposes. However, the officer need only have a reasonable suspicion of criminal activity, not probable cause. An arrest requires probable cause to believe that the arrestee committed a crime. An arrest is distinguished from an investigatory stop by the involuntary, highly intrusive nature of the encounter. Parties state at various points that plaintiff was either detained or arrested. The court finds, based upon the allegations of the complaint, that the plaintiff was arrested. A seizure is not necessarily an arrest, merely because the subject of the detention is placed in handcuffs. So numerous cases have held that a police officer's use of handcuffs can be a reasonable precaution during a Terry stop, right? However, the use of firearms, handcuffs, or other forceful techniques generally exceed the scope of an investigative detention and enter the realm of an arrest. So courts consider the degree of force used in determining whether the seizure was an investigative detention or arrest, and physical restraint as a hallmark factor in determining whether a Terry stop was actually an arrest. And part of that would also be time, right? Because a Terry stop is brief. Is 30 minutes brief? No. A jaywalking ticket should be 5 minutes, maybe 10 minutes. If you're really a stupid cop, 10 minutes. And if you're a cop that's writing a jaywalking ticket, you're a stupid cop, right? Defendants cite U.S. v. Flowers for the proposition that the use of handcuffs did not make the detention arrest. However, in Flowers, the police were investigating a report of an armed man, and a caller had verified that Flowers previously had a gun. An officer may use forceful methods during investigative detention short of arrest only when such methods are necessary for officer protection. 10th Circuit 2009, so that does cover Colorado and Wyoming. The facts as pled do not support a fear that plaintiff was armed or dangerous, especially because Officer Anderson had previously spoken with plaintiff after the plaintiff flipped off the stupid cop the first time. Because Officer Anderson immediately pinned plaintiff to the hood of the police vehicle and then placed the plaintiff in handcuffs for about 30 minutes, the court finds this was an arrest and not an investigatory detention. Officer Anderson detained and ticketed plaintiff under Colorado Springs Municipal Code. The relevant portion of this ordinance states that between adjacent intersections at which traffic control signals are in operations, pedestrians shall not cross at any place except in a marked crosswalk. Plaintiff alleges that Officer Anderson did not have probable cause because there were not two adjacent intersections with traffic signals. Plaintiff notes that the adjacent intersection Anderson pointed out had neither a traffic signal nor a crosswalk, but that the municipal code only prohibits crossing outside of a marked crosswalk between two adjacent traffic signals. Defendants argue that Officer Anderson reasonably concluded that an intersection 2 blocks away was adjacent to the Colorado Avenue intersection. What does adjacent mean? Okay, are you smarter than a 5th grader? Quiz. What does adjacent mean? Okay, stupid cops. How can they even make the argument with a straight face? Sorry, you guys. Plaintiff crossed 30th Street and was arrested in the middle of the block. The intersection to the south with Colorado Avenue is controlled by a traffic light and is marked with a crosswalk. The intersection to the north with Pike Avenue is not controlled with a traffic light and is not marked with a crosswalk. As a result, if the term adjacent means next to, as plaintiff seems to suggest, there were not two adjacent intersections with traffic signals and marked crosswalks, and therefore the ordinance did not apply to him. Defendants, however, point out, however, that the next intersection along 30th Street, the intersection a block and a half away from the point of arrest, is controlled by a traffic light. Therefore, according to the defense, if adjacent means lying near or close to... I'm sorry, you guys. We need to do this. Let's just look up a basic... define adjacent... Okay, adjacent, next to or adjoining something else. Geometry of angles, having a common vertex and a common side. Okay, but so the adjective, next to or adjoining something else. Adjacent. Right now, my middle fingers are adjacent to each other. Now, they are not. Okay, let's try that again, right? Adjacent, not adjacent. Adjacent, not adjacent. Probably should do that, right? What does adjacent mean? Does it mean 1, 2, 3, and then 1 and 3 are adjacent? No! Are you smarter than a 5th grader? Okay. The parties' various definitions of adjacent raises the issue of how the court should consider the interpretation of an ordinance or statute as part of the probable cause analysis. In a qualified immunity context, the probable cause evaluation is a question of law appropriate for resolution of the court. Okay, let's just use the common sense approach. How about that? The reasonable person standard. Would a reasonable person read adjacent to be a couple blocks over? Is that a reasonable person? Reversing a holding that the probable cause determination was a question for the trier of fact, because immunity ordinarily should be decided by the court long before trial. A warrantless arrest is reasonable if the officer has probable cause to believe that the subject committed a crime in the officer's presence. In determining whether an officer has probable cause for an arrest, the court is to examine the events leading up to the arrest and then decide whether these historical facts, viewed by the standpoint of an objectively reasonable police officer, amount to probable cause. Probable cause depends on the totality of circumstances and is not a high bar. A court is guided first by the text of the statute and then by any relevant state or federal decisions interpreting its import. Reliance on a statute or regulation does not make an official's conduct objectively reasonable if the officer unlawfully enforces such ordinance in a matter which a reasonable officer would recognize exceeds the bounds of the ordinance. The determination of whether an officer's reliance on a statute makes his conduct objectively reasonable turns on the degree of specificity with which the statute authorized the conduct in question. The standard is objective. The subjective belief of an individual officer whether there is probable cause is not dispositive. Neither the parties nor the court has identified case law interpreting the meaning of adjacent in the Colorado Springs Municipal Code. This section of the Colorado Springs Municipal Code is identical to the Colorado Model Traffic Code between adjacent intersections. Shall not cross. Hold on. However, the court has not identified any cases interpreting the meaning of adjacent in this section of the Model Traffic Code. Okay. The Oxford English Dictionary defines adjacent as next to or very near something, neighboring, bordering, contiguous, adjoining. Okay? Adjacent. C. Kaufman. Looking to Oxford New English Dictionary to define obstacle in Colorado obstruction of a police officer statute to determine whether plaintiff's actions amounted to probable cause. Almost out of sweet tea, you guys. Based on this definition of adjacent, the traffic signal at the Kiowa Street intersection cannot be considered adjacent. Correct. It is neither next to, neighboring, bordering, contiguous, or adjoining the Colorado Avenue and 30th Street intersection. Even the definition, very near something else, does not reach traffic signal at Kiowa Street. That traffic signal was more than a block away. Defendants argue that the definition of adjacent in Black's Law Dictionary, living near or close to but not necessarily touching, means that Kiowa Street traffic signal was adjacent intersection. As just discussed, however, a traffic signal 2 blocks away is not lying near or close to. Defendants do not explain why, in the context of a jaywalking ordinance that does not otherwise penalize crossing the street except when failing to yield the right-of-way to vehicles, an ordinance would regulate jaywalking between controlled intersections 2 blocks apart, especially given that a pedestrian, due to the distance, would probably not be aware of at least one of the intersection's controlled status. The court finds that the definition of adjacent as next to is consistent with the intent of the ordinance and comports with the plain and ordinary meaning of adjacent. Yes, court. Common sense reading. The court's interpretation of adjacent is consistent with the interpretation of ordinances with identical language from other states. We're not going to read all that. The well-pled facts of the complaint state that the intersection next to plaintiff did not have a traffic signal. Because the municipal ordinance only prohibits crossing outside of marked... Okay, therefore the court finds the plaintiff has pled sufficient facts that when viewed from the standpoint of a reasonable officer are insufficient to establish probable cause to arrest plaintiff for violating municipal code. In defendant's reply, defendants argue that plaintiff concedes that the intersections of 30th and Colorado and blah blah are adjacent and that thus Officer Anderson had probable cause. The court disagrees. Plaintiff's complaint and response both argue that plaintiff did not cross between adjacent traffic signals. Yeah, I read the initial complaint and that's... Okay, stupid cops. Okay, when a warrantless arrest or seizure is the subject of a 1983 action, the defendant is entitled to qualified immunity if a reasonable officer could have believed that probable cause existed to arrest or detain the plaintiff. In the 10th Circuit, as a practical matter, in the context of a qualified immunity defense, we ascertain whether a defendant violated clearly established law by asking whether there was arguable probable cause for the challenged conduct. So, the stupid cop is entitled to qualified immunity if he could have reasonably believed the probable cause existed in light of well-established law. Having found that the plain language of the ordinance did not give rise to probable cause to arrest plaintiff, the court also finds that Officer Anderson's arrest was not reasonable. The ordinance does not generally forbid crossing outside of a crosswalk. Instead, it states that blah, what we just read. A simple glance at the intersection would have revealed that there was no traffic signal. Okay, hold on. Plaintiff argues that actual probable cause is the law of the 10th Circuit and cites. However, Bailey is not binding precedent. Instead, the court will follow Corona versus Aguilar, which is also a good case. Did I cover that last year? A more recent published opinion. Plaintiff also attempts... I think I covered Aguilar last year, didn't I? Attempts to cabin arguable probable cause to cases where there was a warrant. However, Corona was a warrantless arrest and the court therefore rejects plaintiff's argument. Any mistake that this intersection had a traffic signal cannot be considered reasonable. Therefore, Officer Anderson violated his clearly established right to be free of an arrest, unsupported by probable cause when he made the unreasonable determination that plaintiff had violated the ordinance. So, He will deny defendant's motion to dismiss claims 3 against Officer Anderson in his individual capacity. Because it's clearly established. Okay. Plaintiff alleges that the search of his person while he was handcuffed was unlawful. And again, here, it will always be my argument that if the arrest is unlawful, any search incident to that arrest is unlawful. And yes, in the video, you actually see them going into his pockets. So not a pat down, but a full search. If you are under arrest, they can search you to that, right? Incident to the arrest. But they claim he was only detained. So, But the court found that he was under arrest. So does that work against the plaintiff? We'll find out. Plaintiff alleges that the search of his person while he was handcuffed was unlawful. Plaintiff alleges that Officer Anderson directed another officer to search plaintiff's pockets. Plaintiff brings no claims against Officer Calderon in this lawsuit. A government actor may be liable for the constitutional violation of another if the actor set in motion a series of events that the defendant knew or reasonably should have known would cause others to deprive the plaintiff of his constitutional rights. He may be held liable for Officer Calderon's allegedly unlawful search if he approximately caused the officer's conduct. The complaint alleges that Officer Calderon searched plaintiff at his direction. There were no intervening events, and Calderon's search of plaintiff was the foreseeable result of Officer Anderson's direction to him to search plaintiff. Therefore, plaintiff may properly allege a fourth violation against Officer Anderson, even though Officer Anderson did not search him. A warrantless search of a person or place is permissible when contemporaneous to an arrest. However, because the fact of the lawful arrest establishes the authority to search where probable cause for the arrest is lacking, the subsequent search is unconstitutional unless supported on other grounds. Among the exceptions to the warrant requirement is a search or incident to a lawful arrest. However, given the court has found that based on the well-pleaded facts, the arrest was not supported by probable cause, the search of a plaintiff incident to arrest is also a constitutional violation. And that's 10th Circuit. Yeah, because I think, I do believe that fact, I don't believe the Supreme Court, I'll have to look into that. Has the Supreme Court actually found that? Or has that all been decided by circuit courts? Because this court concludes there was not probable cause to support the warrantless arrest, the pat-down search incident to arrest was also improper. The pat-down search. They put their hands in his pockets. That's not a pat-down search. The law is clearly established that officers need either a warrant or a valid exception to the warrant required in order to search a person. However, plaintiff's arrest was not supported by probable cause and excessive force. A plaintiff must show both that a seizure occurred and that the seizure was unreasonable. The relevant inquiry is whether the force used by Officer Anderson was reasonable under the facts and circumstances presented. When examining a claim of excessive force, a court assesses the reasonableness of an officer's conduct from the perspective of a reasonable officer on the scene, acknowledging that the officer may be forced to make split-second judgments in certain difficult circumstances. Defendants also argue that this was a permissible pat-down pursuant to a Terry stop. However, as noted above, the court has found that plaintiff was arrested, not subject to investigative detention. Therefore, this was not a Terry stop that could support a pat-down search. Moreover, the 10th Circuit has only allowed an officer to conduct a pat-down search or frisk if he or she harbors an articulable, reasonable suspicion that the person is armed and dangerous. None of the facts in the complaint give rise to an articulable and reasonable suspicion that plaintiff was armed or dangerous. This test applies despite the fact that Officer Anderson did not have... Okay. So, they're saying that no matter what, was it reasonable, was his behavior reasonable, even if he didn't have probable cause for the arrest? Plaintiff argues that officer actions were excessive as a matter of law. Taking the facts of the complaint as true, Officer Anderson grabbed plaintiff, pulled him to the police car by his wrist, shoved him onto the hood of the police car. Plaintiff did not resist, but Officer Anderson continued to pin him to the hood of the police car and wrench his arms behind his back. Though not part of the allegation regarding excessive force, the court notes that Officer Anderson then placed plaintiff in handcuffs, and plaintiff remained in handcuffs for the remainder of the encounter, about 30 minutes. Defendants argue that plaintiff has not shown an injury which is required in this excessive force claim. The Tenth Circuit considered an excessive force claim related to handcuffing, because handcuffing is appropriate in nearly every situation where an arrest is authorized. It presents an issue where the handcuffing may be allowed in the manner in which it is done could render the force excessive. The court held that where an excessive force claim rests on the manner of handcuffing, the plaintiff must show both that the force used was more than what was reasonably necessary, and the plaintiff suffered an actual injury that was more than de minimis, minor. These big words with multiple letters right next to them, anything bigger than that for me. The Tenth Circuit has clarified that the de minimis injury requirement only applies in handcuffing cases. Defendants cite Anderson v. Arnold, 10th Circuit, unpublished, not binding, where the court did imply the requirement of actual non-de minimis injury for an excessive force claim unrelated to handcuffing. However, the reasoning is brief and contained in an unpublished opinion. The complaint does not allege that Officer Anderson wrenched his arms behind his back in order to handcuff the plaintiff. While defendants are correct that it would be a reasonable reading of the facts to conclude that Officer Anderson was attempting to position plaintiff for handcuffing, the court cannot draw that conclusion in defendant's favor. The court need not resolve whether plaintiff was required to plead facts of non-de minimis injury because, as explained below, the force used by Anderson was not excessive, irrespective of showing an injury. Well, you guys just ruined that. Spoiler alert. Spoiler alert. The force was not excessive. Plaintiff cites a number of cases to support the proposition that the use of force against a restrained and subdued individual is excessive as a matter of law. Court finds that each of the cases plaintiff cites is either distinguishable or, in fact, supports the amount of force Anderson used to restrain the plaintiff. So we're not going to go through these. I'm kind of pissed off about that spoiler alert, man. I want to find out, court finds Dixon versus Riker, to be the most informative case. In Dixon, police officers had a reasonable basis to commit an investigative stop of the plaintiff, despite the fact that the plaintiff was not suspected of committing a crime. Plaintiff submitted to being frisked by putting his hands against the side of his van. When police officer kicked him during the frisk, the plaintiff turned around and said, "Is that fucking necessary?" Several minutes later, the officers frisked the plaintiff again, and in the course of which the officers kicked the plaintiff again, hit him in the stomach with a metal flashlight, and then began to choke and beat him. The court held that the initial kick was reasonable given an uncertain, potentially dangerous circumstances, but the subsequent beating, when plaintiff had already been frisked and was not making any aggressive moves or threats, was unreasonable, and plaintiff had shown a Fourth Amendment violation sufficient to survive summary judgment. The cases above support Officer Anderson was entitled to use minimal force to restrain plaintiff, grabbing his wrist, pushing him against the car, leaning him over the hood of the car, actions typical of an arrest. Plaintiff additionally alleges that Officer Anderson pinned him to the hood of the vehicle with his entire body weight and wrenched his arm behind his back. Plaintiff has not cited any case where a court has found a constitutional violation based on a similar level of force. Plaintiff was unrestrained, and Officer Anderson was entitled to use some force to effectuate the arrest. The court finds that Officer Anderson's use of force to restrain plaintiff was not excessive because though minimal force was necessary under the circumstances, Officer Anderson only used the force required to restrain the plaintiff. Therefore, the court will grant defendant's motion to dismiss Claim 5 with respect to Officer Anderson in his individual capacity for failure to plead a constitutional violation. But again, you guys, it's going to always be my argument that any force used to arrest somebody illegally is excessive. I don't care if you break a fingernail. That is excessive. A break of my hair is excessive. I got hair on my arms here, so if I lost one of them in a illegal arrest, that is excessive because the arrest is illegal. Obviously, they disagree with me, so the 10th Circuit disagrees with me. And the Supreme Court, I don't know if they've ever actually answered it. I know they didn't cite any Supreme Court cases in the above. Claim 6, Fourth Amendment violation of malicious prosecution. The elements of a malicious prosecution are, we're at 35 minutes. Defendant caused the plaintiff's, and this is only page 23, shnikes, caused the plaintiff's continued confinement or prosecution. The original action terminated in favor of the plaintiff. No probable cause supported the original arrest, continued confinement, or prosecution. The defendant acted with malice and the plaintiff sustained damages. A court may infer malice if a defendant causes the prosecution without arguable probable cause. Defendants argue that plaintiff does not plead facts sufficient to show that the original action terminated in plaintiff's favor. The case was dismissed. The complaint alleges that the charges against Mr. Sexton resulting from the actions or omissions of defendant described herein were dismissed. Thus, the original action against Mr. Sexton terminated in his favor. The 10th Circuit considered what constituted a favorable termination. The prosecutor had filed a null prosecute, which was, we will not prosecute you. The court found that abandonment is ordinarily insufficient to constitute a favorable termination. The termination must indicate the innocence of the accused in some way. No, because that's going to be a rare day when a prosecutor says the cops fucked up on this case. That prosecutors are not going to do that because otherwise they're going to make enemies of their friends, the cops. They're not going to ever do that. When it is unclear whether a termination indicates innocence, the court looks to the stated reasons for the dismissal as well as the circumstances surrounding it and determine whether the failure to proceed implies a lack of reasonable grounds for the prosecution. The fact he didn't break the law is favorable. God, they are so stupid. Parties disagree whether arguable probable cause is sufficient to entitle an officer to qualified immunity on malicious prosecution claim, or whether actual probable cause is required, because the court finds the plaintiff has not sufficiently alleged that the original action terminated in his favor. So again, spoiler alert. How can they find otherwise? No, before we actually read their freaking reasoning on this. They say he is illegally arrested. They say, yes, he was arrested. They say that he did not violate any law that any reasonable officer would find that he violated. Yet somehow, when the prosecution dismisses the case of an illegal arrest of a law that was not violated, it didn't terminate in his favor? How the fuck else are you ever supposed to prove that? Seriously, any cop out there, any lawyer out there, tell me, how is that ever supposed to be proven? Under these circumstances. Any way at all. If the bar is only that... Yeah. In view of the circumstances, the case was disposed of in a manner that leaves the question of the accused's innocence unresolved. There generally can be no malicious prosecution claim by the accused. And I am going to be looking at all this case law on this one. I really want to figure out this malicious prosecution. It blows my mind. Plaintiff's assertion that the dismissal of the charges indicates that the action terminated in plaintiff's favor is insufficient to support a finding of favorable termination. Finding plaintiff did not plead sufficient facts at motion to dismiss stage to support finding action. That's exactly what you just said there. Granting a police officer's motion to dismiss malicious prosecution claim where the government filed a nolle prosequi. Okay, that's the will not prosecute you, right? In the interest of justice, yeah. Plaintiff argues that the fact that Officer Anderson was disciplined for violating the police department's discretionary judgment policy at the same time as the charges were dropped is evidence that the prosecutor dropped the charges because there was a lack of probable cause for the arrest. However, there's no probable cause because he didn't violate the law. With a plain reading of the law, or even 5th grade reading of the law, he didn't violate it. Therefore, there was lack of probable cause for the arrest, and he didn't violate the law. However, the complaint does not allege that Officer Anderson was disciplined for his arrest of plaintiff. Instead, alleges that Officer Anderson was not disciplined for his wrongful arrest, clear violation of the First Amendment, and unlawful use of force. Plaintiff has not sufficient... Yeah, that was a poor argument. The decision by GSPD to discipline Officer Anderson for a violation may have been unrelated to his arrest means that the prosecutor's decision to dismiss the charges was indicative of plaintiff's innocence. Court finds that the plaintiff has not alleged facts sufficient to show that the prosecution terminated in his favor. Accordingly, he fails to establish a constitutional... I've got to... I've got to look at all these cases now. I've got to save this file. I'm going to do that now while I'm thinking of it. And this is Pike, Sexton versus Colorado Springs. Order to... Oh, I already saved this. Okay. I did save it. I thought I did, but it didn't come up in my list of files. So, okay. Yeah, I've got to look over all that case law and maybe do a video on that. 'Cause I'm not understanding that argument. Violation of his free speech by detaining and ticketing him for... And we shouldn't be reading those footnotes if they're going to provide spoiler alerts, because that's just ruining the whole video. Plaintiff alleges that this was content and viewpoint-based restriction on speech. Defense argued that given plaintiff has not identified a court order, law or policy, or regulation that restricts plaintiff's ability to speak, plaintiff fails to state a claim distinct from his First Amendment retaliation claim. That's actually a good argument. That's actually a good argument. It's either one or the other, isn't it? Court found the plaintiff had failed to plead a First Amendment content-based restriction that was separate from the plaintiff's First Amendment retaliation claim. In Wise, the plaintiff did not identify or challenge specific law, regulation, or policy that restricted her ability to speak. Yeah, I've got to agree with that. I mean, court treated the content-based restriction claim the same as the plaintiff's retaliation claim because the plaintiff failed to articulate a distinct and legally supporting basis for it. Plaintiff here argues that he has pled a legal theory distinct from his retaliation claim, where the plaintiff brought an as-applied First Amendment claim in addition to a claim for retaliatory arrest. The court held that, though the claims were closely related, the plaintiff had pled two distinct legal theories. Defendants argue that Brandt is distinguishable because the plaintiff had been arrested pursuant to a disorderly conduct municipal ordinance. Court finds Wise distinguishable because the plaintiff in Wise was not arrested. Here, plaintiff alleges that his arrest was a content-based restriction on speech that is distinct from his retaliation claim. An arrest by a police officer can give rise to a claim for content-based restrictions on free speech. Finding genuine. Defendant's argument that Claim 1 should be dismissed is based entirely on the notion that Claim 1 is duplicative of Claim 2. However, because an arrest can give rise to a content-based restriction on free speech, plaintiff has pled a distinct basis for Claim 1. Therefore, the court will deny defendant's motion to dismiss against Officer Anderson in his individual capacity. Footnote. So they just argue that he's entitled to qualified immunity on all claims. Therefore, defendants do not adequately assert the defense of qualified immunity on Claim 1, and the court only determines that Claim 1 is not duplicative of Claim 2. Okay, I'm going to skip the other one and go back to it after we're done with the whole section of Claim 2 because I don't want spoiler alerts. Generally, the First Amendment prohibits government officials from subjecting an individual to retaliatory actions for engaging in protected speech. To establish a First Amendment retaliation claim, plaintiff must demonstrate 1. That he was engaged in a constitutionally protected activity, 2. That the defendant's action caused him to suffer an injury that would chill a person of ordinary firmness from continuing to engage in that activity, and that 3. The defendant's action was substantially motivated as a response to his exercise of his First Amendment speech rights. Ordinarily, a plaintiff must plead and prove the absence of probable cause for the arrest, which he's already done. Defendants argue that plaintiff's allegations fell each prong of retaliation. So defendants are arguing that he fails each prong of it. Defendants argue that plaintiff was not engaged in a constitutionally protective activity because jaywalking is not constitutionally protected. However, plaintiff argues that his constitutionally protected activity was flipping off Officer Anderson. The court agrees that the First Amendment activity alleged in the complaint was criticism of the police on a public street, which is a constitutionally protected activity. And that's a Supreme Court case. Houston versus Hill. Defendants argue that plaintiff did not suffer an actual injury because the only injury he alleges is feeling pain in his arm before being handcuffed. Plaintiff responds that a retaliatory arrest is an injury sufficient to chill a person of ordinary firmness. Court finds that a retaliatory arrest, unsupported by probable cause, is an injury that would chill a person of ordinary firmness. And that's a 10th Circuit case. Unpublished, though. So, I don't understand why sometimes they agree unpublished means that it's precedent and sometimes unpublished means it's not precedent. I don't get it, you guys. I don't get why sometimes they can turn to unpublished but sometimes they can't. Pursuit of an arrest without because just earlier they said that it's unpublished, therefore we're not going to follow it. But there was no case law arguing against it either. So, a pursuit of an arrest without probable cause would chill a person of ordinary firmness. Okay. Additionally, the court has found the absence of probable cause. Therefore, the only issue left of defendant's argument that plaintiff has not stated a claim for First Amendment retaliation is whether plaintiff has adequately pled a retaliatory motive. Defendants argue that the facts as pled by plaintiff do not show a retaliatory motive. The retaliatory motive must be a but-for cause, meaning that the adverse actions against the plaintiff would not have been taken absent the retaliatory motive. The Supreme Court case Neves would not. Okay, so the adverse action against the plaintiff, he would not have been arrested absent the retaliatory motive. Okay, I've got you now. Recognizing that although it may be dishonorable to act with an unconstitutional motive, a official's action colored by some degree of bad motive does not amount to a constitutional tort if the action would have been taken anyway. How does that apply in this case in any way? Plaintiff alleges that after he flipped off Anderson from the 7-Eleven parking lot. He made a U-turn across 4 lanes of traffic and contacted plaintiff. After Anderson and plaintiff spoke, Officer Anderson began to drive away and he told me, "Kick rocks!" And plaintiff crossed the street outside of a crosswalk. Anderson then made another U-turn and began to drive towards plaintiff. Plaintiff started recording the incident on his phone and flipped Officer Anderson off again. Immediately after plaintiff began recording and flipped Officer Anderson off again, Anderson turned on his police lights. He gave shifting reasons for arresting plaintiff before telling plaintiff they detained plaintiff for jaywalking. He alleges that Officer Anderson arrested plaintiff for flipping him off. The close temporal proximity between plaintiff's protected speech and his arrest without probable cause can give rise to a strong inference that Officer Anderson was substantially motivated to arrest the plaintiff because of his protected activity. Okay, we're going to ignore the fact that because of we're going to ignore the missing words. And so that's a 10th Circuit case, okay? Defense argued that Officer Anderson recontacted plaintiff because of his illegal act. But the court has already determined that there was no probable cause to arrest plaintiff. The court finds that the close temporal proximity to the protected speech and arrest, combined with the absence of probable cause and the fact that Officer Anderson did not turn on his police lights until plaintiff flipped him off the second time, is sufficient to plead that a retaliatory motive was the but-for cause of his arrest. Plaintiff has therefore pled each element of First Amendment retaliation claim, but the court has found that the plaintiff pleads a claim for retaliatory arrest. The court will deny defendant's motion to dismiss the claim 2 in his individual capacity. Now, what does this one read? Supreme Court's holding that probable cause defeats a claim for retaliatory arrest. Okay, that's good. Wasn't there another one? I thought there was. Because plaintiff has sufficiently pled the absence of probable cause for the arrest, court does not address the parties' arguments concerning the exception. Okay, now I understand. Okay. Okay, City of Colorado Springs. So, plaintiff brings claims 1, 2, 3, 5, and 6 against Colorado Springs. Plaintiff alleges that Colorado Springs has a policy or custom of content-based restrictions on free speech, retaliation for engaging in protected speech, and unlawful seizures. Local governments may not be sued under Monell theory, right? Okay. Yeah. Municipal policy has a custom policy. Complaint and claim 3 alleged. Really, you guys, we know that this is dismissed, so I'm just looking for anything good. That generally, plaintiff has been targeted by CSPD for criticizing the police. The complaint alleges 4 instances of retaliation for exercising First Amendment rights and 7 instances of arresting individuals without probable cause. Plaintiff was subject to multiple harms by Officer Anderson's unconstitutional conduct. Plaintiff alleges the specific topic of the challenge policy or training inadequacy. Colorado Springs ratified these customs and practices, and these customs caused plaintiff injury. Court construes plaintiff's arguments to be that he can establish a policy of First and Fourth Amendment violations because Colorado Springs has a widespread practice of tolerating First Amendment violations and arresting people without probable cause, as evidenced by incidents described in the complaint. 2. Final policymakers ratified subordinates' decisions to engage First Amendment violations and arrest without probable cause. 3. Colorado Springs has a policy of failing to train its officers or to allege municipal claim. We've already covered Monell pretty well. So, he alleges 12 incidents of interactions between citizens in Colorado Springs. He alleges 1 incident in 2019 where he was arrested without probable cause for engaging in protected speech. Plaintiff also alleges a 2013 where Colorado Springs Police Department officers were arrested an individual for verbally protesting the stupid officer's beating of another man. 2015, arrest of an individual for filming a traffic stop. 2017, detention of an individual because the individual filmed police. Retaliatory actions in 2016-17 by the police, city council and city attorney against an individual for whistleblowing on a government entity. The court first considers which of these 4 alleged incidents are sufficiently similar to the facts of this case. Therefore, it's dissimilar to the facts. It's dissimilar. How on point do the arrests actually have to be? Basically, though, all of the claims failed under Monell. So, city defendant's motion to dismiss, granted in part. Oh, wait. Ooh. What survived? Two, three. Okay, so Colorado Springs is completely dismissed. Okay, that's what I thought, but okay. I still don't understand all those claims. I don't understand. I'm going to have to look into this, you guys. If I find it interesting enough, if I find the case law, I really want to find out about the malicious prosecution. I want to look at that case law. I guess I've never really dug into it, because why would a prosecutor ever say the guy is innocent, so I'm dropping the case? In this case, they found that the guy didn't violate the law. That is the same thing as being innocent. That is the same freaking thing as being innocent. If you didn't violate the law, you are innocent. Somebody, share this with your the other YouTubers. I really want to know. Malicious prosecution. If you did not violate the law, then and the case was dismissed, that is in your favor. You didn't. This court found that you didn't violate the law. That it was an illegal arrest. How is that not malicious prosecution with their definitions? Alright, guys, I'm going to go ahead and end this. Thank you for joining, and have a great night.